I wish, with your permission, to make a statement on the circumstances leading to the judgment which the Judicial Committee of the Privy Council, composed of Lord Reid, Lord Kerr, Lady Black, Lord Briggs and Lord Sales gave last Monday, 10 June 2019. The judgment was a judgment and appeal from a decision of our Supreme Court composed of their ladyships A.F. Chiu Yu Chong and R. Tilok, and delivered on 7 July 2016 in the matter of an application by the Mauritius City Power Limited for the judicial review of a decision taken by government not to proceed with the City Power project. This judgment has far-reaching legal and political implications and is poised to become a leading case in Mauritius administrative law, as well as in the law of the United Kingdom and of several countries of the Commonwealth. Madam Speaker, in December 2005, a few months after the installation of a new government, following the July 2005 elections, the Board of Investment received an unsolicited proposal from City Power Malaysia Limited for the implementation of a 2 times 55 megawatt coal power plant. The project was to be implemented by a local subsidiary. In April 2006, that is 4 months after receipt of this unsolicited proposal, the Board of Investment issued a letter of intent to the local subsidiary, the Mauritius City Power Limited, which had been incorporated on 15 March 2006. BOI's letter of intent indicated that the 3 times 50 megawatt, that is 150 megawatt coal-based power station, may be accommodated in CEB's power expansion plan. The project also included a jetty for coal handling at Puerto Cave, Albion. The letter of intent was valid up to 22 October 2006. On 29 June 2006, that is half a year following receipt of the unsolicited proposal, the Ministry of Housing and Lands approved the grant of an industrial lease of approximately 80 acres of land at Puerto Cave, Albion, to the Central Electricity Board for the purpose of setting up a coal power plant. Less than 1 month later, that is 26 July 2006, the CEB Board approved that discussions be initiated with the company for a 100 megawatt instead of a 150 megawatt plant. On 30 September 2006, the Board of Investment extended the letter of intent to October 2007. In October 2006, the Ministry of Energy and Public Utilities gave approval for the project. In October 2008, the then government agreed to lease 92 acres of state land at Puerto Sab to CEB at the nominal value of 480,000 rupees per annum, to be adjusted every 3 years by cumulative inflation rate. The CEB would sublease the site to the Mauritius City Power Limited at full market rate as assessed by the Director of the Valuation Department, and use the funds for the sublease of the land for an equity participation in the City Power project. In the same year, the CEB incorporated a subsidiary known as the CEB Investment Company Limited, which signed a shareholders agreement on 23 December 2008 with the Mauritius City Power Limited. It was to hold 26% equity participation and have 3 directors on the board of the company. On 23 December 2008, Although no EIA license had yet been obtained, the CEB, represented by its general manager, its then general manager, signed a coal supply agreement, providing for CEB to be responsible for the procurement of some 350,000 metric tons of coal annually to be imported from South Africa, and for the Mauritius City Power Limited to be responsible for unloading, handling, storage, and transfer of the coal to the power station. The Mauritius Ports Authority put at the disposal of the CEB a plot of land of about 1.3 hectares in the port compound to be subleased to the Mauritius City Power Limited for the unloading and transfer of coal. B, a power purchase agreement providing for CEB to buy electricity from the Mauritius City Power Limited at an agreed tariff for a period of 20 years, and thereafter the transfer of the power plant to CEB at a nominal sum of $1. C, an interconnection facility design and build agreement relating to the design and construction of a substation at Pointe-aux-Câbles and the transmission network up to La Chaumière substation, estimated at $9.9 million to be executed within 23 months. Madam Speaker, an application for an EIA was made in 2009 at the Ministry of Environment, which obtained UNDP assistance to appoint an independent consultant, Mott MacDonald, to evaluate and assess the application. In May 2009, the consultant submitted its report, based on which the EIA committee requested the promoter to carry out additional studies, which, in addition to the environmental concerns, included the technical viability of the socio-economic assessment and cost-benefit analysis. On 16 June 2010, the promoter submitted the additional report, and in January 2011, the EIA committee recommended to the minister that the EIA license should not be issued. On 16 July 2012, following an appeal by the promoter, the Environment Appeal Tribunal gave its ruling in favor of the Mauritius City Power Limited, and on 23 January 2013, the Ministry of Environment issued the EIA license with 31 conditions, including condition 15, that the promoter shall undertake, I quote, to provide proof of its financial capabilities for the duration of the project to the satisfaction of the Ministry of Finance and Economic Development, end of quote. In December 2013, the CEB, represented by its chairperson and general manager, signed an amended power purchase agreement to incorporate the requirements of the EIA. The purchase price of electricity would be 4 rupees 58 per kilowatt hour, which was to include the annual cost of lease of the land and coal delivered at the port. It excluded the cost of transportation of coal from the port to the power station, amounting to 10 cents per kilowatt hour, and the power transmission from the plant to the substation at La Chaumière, estimated at 17 cents per kilowatt hour. The price would change on the basis of indexation formula over 20 years. Madam Speaker, the CEB's commitment in the project included an amount of USD 18 million as equity participation, 700 million for the construction of a jetty, and 600 million for underground cables, as well as cost of obtaining wayleaves. These wayleaves were subject to court cases. The effective date of the power purchase agreement was subject to the signing of an implementation agreement. The implementation agreement served as government guarantee for the payment obligations of the CEB and is therefore a financial commitment for government. The Ministry of Finance and Economic Development at that time therefore asked the Mauritius City Power Limited to submit a letter of comfort from its banks to confirm its financial capacity. The letter submitted by the promoter was not to the satisfaction of the Ministry of Finance. Thus, in March 2015, Government decided not to proceed with the City Power project. Madam Speaker, on 25 May 2015, the Mauritius City Power applied to the Supreme Court for leave to apply for judicial review of the decisions of government, of the Ministry of Finance and Economic Development, and of my ministry. The proceedings were also directed against the Minister of Finance and Economic Development and myself in my capacity as Minister of Energy and Public Utilities. The Central Electricity Board was joined as an interested party. On 7 July 2016, the Supreme Court, composed as aforesaid, ruled in favor of the Mauritius City Power and held that my decision, as well as that of my ministry, not to sign the implementation agreement was misconceived, unreasonable, and irrational, and in breach of the legitimate expectation of the company. A similar finding was made against the Minister and the Ministry of Finance and Economic Development. The Supreme Court was of the opinion that the Mauritius City Power had the legitimate expectation that the implementation agreement would be first signed and that the Mauritius City Power would have 9 months after signature to provide proof of its financial capabilities. As regards the Ministry of Finance, the Supreme Court was of the view that its decision was equally misconceived, unreasonable, and irrational, and in breach of the legitimate expectation of City Power. In March 2017, that is after the judgment of the Supreme Court, the Mauritius City Power entered a claim for damages for some 4 billion rupees. The claim is directed against the state of Mauritius as well as other parties. The matter is still pending. The state of Mauritius appealed against the judgment of the Supreme Court to the Judicial Committee of the Privy Council. In his judgment of 10 June last, the Judicial Committee of the Privy Council unanimously quashed the judgment of the Supreme Court. I am tabling a copy of the judgment of the Judicial Committee and draw attention especially to paragraph 65 of the judgment, in which the noble lords held inter alia that as minister I was, I quote, entitled to have regard to a wide range of considerations, including political considerations. End of quote. Adding that, and I quote again, entering into the implementation agreement would involve a commitment requiring substantial payments of public money. There is inevitably a possible political dimension to such questions which it would be legitimate to take into account. In the present case, continued their noble lords, it appears that the incoming government after the general election of December 2014 may have been less convinced than the former government that the project was a good idea and that the commitment to be given in the implementation agreement was justified. I repeat, may have been less convinced. At paragraph 67, the Judicial Committee of the Privy Council also held that I was, I quote, entitled simply to take the view that all things considered, city power did not appear to be a satisfactory counterparty and that it was undesirable for the implementation agreement to be entered into. The Judicial Committee of the Privy Council has therefore quashed the order made by the Supreme Court and has given judgment in favour of the State of Mauritius, in favour of the Ministry of Finance and Economic Development, the Ministry of Energy and Public Utilities, and their respective ministers. It is expected that the Mauritius City Power will have to pay the cost of the case.